let's see. You want to get started with the intros?
Sure.
Sure. I'm Amanda Vaught. I'm not really speaking today, but I'll be more doing moderating and hosting. As some of you have heard, the chat box isn't working. So if you do have a question, please use the Q&A box, and I'll be monitoring that throughout the presentation. And we would love to get your questions, comments, thoughts, anything that comes up while we present. It's when we do these webinars, it's hard because we can't see the audience. So we don't know, what's resonating, if you're getting really into it, or if you're sleeping. So anything.
Getting really into it. I wonder what that looks like.
Yeah, I don't know who gets really into it, but yeah, please don't hesitate to type something in there in the chat, and not in the chat, in the Q&A. Also here today is our special guest, Patrick McKenrick. He is an attorney in Knoxville, Tennessee, and he specializes in trusts and estates. David Vaught, also here. Do you consider yourself an attorney, former attorney? I say.
Hey, Amanda, can you scroll down to the bio pages when you're doing it?
Oh, sure. We can do that. This is a little more about me. If you would like to see that, here's Patrick. Danielle, also an attorney in Tennessee. She's been a lawyer for what, 20
years this year.
20 years, okay. And financial advisor for what, 24?
Yeah, almost, yeah.
Okay, so a lot of experience here, and also going back to David, also background as an attorney, not practicing anymore, but it's been a financial advisor for what, if you're 24, what's David,
25, I guess.
25 years.
Roughly, yeah.
So we bring a lot of experience, a lot of education, maybe unfortunately too much experience working with estates. I think in the promo materials for today, we mentioned that we've had too much experience with estate planning recently. We've lost a lot of good people. And some of them had their estate plans in place, and some of them unfortunately did not. And so today we wanted to go through what's involved in an estate plan. We split up the talk sort of into two halves: the before, what you can do to plan in advance, and then the second half will focus on the after, what happens after a loved one dies. So Patrick will be focusing on some of the legal planning we can do. David will get into some of the financial planning aspects, and Danielle, I think, is covering some financial planning as well, and also some tax planning we can do that can impact you and your loved ones. I also just want to say, for as far as estate planning, most people do not have their estate plan done. I think the statistics is less than 40% actually have it done. I think, it can be hard for people to deal with this, to talk about it. But I recently saw in the news Anne Heche passed away, the actress, in a tragic car accident, and they said that her son recently filed in the probate court because she died without a will. And that's her son. He's 20 years old. He lost his mother abruptly, and now he has to deal with this. So we would just want to encourage you to do what you can in advance. We realize it's hard, but hopefully today will give you an idea of what's involved and what actions you can take so that that doesn't happen to you or your family. So I also just need to address a couple housekeeping things. In today's presentation is for educational purposes only. We are not giving you any legal advice, investment advice, or tax advice. If you have a specific question about your individual situation, please reach out to your financial advisor, if it's us, your tax advisor, or your own attorney. And with that, I will let Patrick take it away.
Great. Well, thank you, Amanda, and thank you to Propel Financial Advisors for inviting me to participate in this webinar. Very much appreciated. like as my introduction said, I practice basically exclusively in trust and estates, which involves both the planning, the before legal planning side of things, and also the after when someone passes away. The theme for the before planning in my mind is really your control over what happens. And so you'll see this slide lists 4 different types of legal documents that you would typically have in place in a complete estate plan. The first couple of them are generally in effect prior to death. So the durable power of attorney for property. Now, this could also be referred to as a durable power of attorney for financial and business affairs. Sometimes it's just referred to as a durable general power of attorney. But what this document does is it allows you to make a choice of who your agent or agents will be to handle your personal financial business for you, and which is incredibly important. So I will frequently meet with married clients who will ask me, well, do I need a power of attorney for finances in place? I'm married. Can my spouse not just handle these things for me? And oftentimes the answer is no. There are such strict financial regulations on banks. If you have bank accounts in one person's name, your spouse may not be able to conduct any business on those accounts, or with companies. I've worked with one of my clients had an ADT account. It just happened to be in her husband's name. And without that power of attorney, she couldn't communicate with them at all, even though it's the security system for her home. So the power of attorney for property is absolutely essential, as you need to have someone there who can handle these things for you, especially in the event that you cannot do it. Because the alternatives that the law offers us are not that great. The primary alternative to a power of attorney for property would be a conservatorship, which is where someone would go before a court and the court would decide who gets to make these decisions for you. And that's going to cost more money. That's going to have much less privacy. You'll have not only a judge, but at least 2, maybe 3 lawyers involved in the process, and less choice. So having a power of attorney in place lets you make that decision in advance. It allows you to authorize that agent of your choosing, which is very similar with a healthcare power of attorney. Again, this is your choice of an agent to handle medical decisions for you. And sometimes even more importantly, get access to records, communicate with doctors, work with pharmacies, and that sort of thing. Now, I tell my clients when I meet with them that your doctor is always going to try to communicate with you if they can. And however rudimentary that might be sometimes. But if your doctor can't communicate health decisions with you, then your agent, as named in the healthcare power of attorney, is the person that will have authority to do that. And again, they'll be able to go to bat with, the pharmacy or the insurance and that sort of thing. And your alternative here is just like with a power of attorney for property, your alternative is a conservatorship, which is going to be more costly by an order of magnitude, much less private. And again, you don't have the control. You don't get to pick who the court is going to appoint unless you do the planning in advance. And that's why it's so important. So these first 2 documents, the powers of attorney, are mostly in effect during your lifetime. The last 2 become very important at your death. The last will and testament. As a trust and estates attorney, I believe that everyone should have a will. And what does it do? Its basic purpose is to dispose of your property at death. And property that is in your name alone, property that's not payable to someone else, but property that's in your name alone. It also names an executor, someone who can wind up your financial affairs for you, be that filing tax returns, distributing assets, paying creditors. And the will, again, it lets you have control over who this person is going to be, who your fiduciary is going to be, and it lets you have control over where your property is going to go. So if you don't have a will in place, what are you left with? Well, the legal word that I would use would be intestacy. And what that means is that there is, whatever jurisdiction you live in, there is a set of laws on the books that says who gets your property if you die without a will. Now, that set of laws on the books can run contrary to your usual expectations. So 99 times out of 100, if I have married clients, they're wanting to leave the vast majority of their estates to one another, or at least for the benefit of one another in some way. The Tennessee intestate succession statute will split the estate between surviving children and the surviving spouse. So, for example, if you have 2 children and a surviving spouse, each child could get 1/3 of the probate estate, whereas the surviving spouse only receives 1/3. I have yet to meet with a married couple client that wanted to leave 1/3 of their estates to each other. So it is incredibly important that you plan in advance so that you can make the choices about where your property goes. So there are some other things that a will can handle that the intestate statutes can't. So the wills can let you waive certain things that add expense to a probate administration. It makes it definite who's going to serve as executor, and wills can handle special circumstances better than the statutes can. So if you have young beneficiaries who shouldn't have access to money until they're 21 or 25, or if you have beneficiaries with certain types of special needs, these can be addressed through a will, and you are not going to be able to address those effectively if you died without a will. And so all of my clients who I do estate planning work for will get a will. And some will also get a revocable trust or a revocable living trust. In many ways, this is considered a will substitute. And in lots of jurisdictions, the primary benefit might be the avoidance of probate. So in a well-prepared revocable trust that is adequately funded, so if your attorney is working in conjunction with your financial advisor and everyone's on the same page and it's properly funded, can avoid probate altogether. So what does that mean? You don't file the revocable living trust in court. You don't have to subject it to certain states' default rules regarding attorney's fees. There are states where you're paying 10% of the probate estate in attorney's fees, which can be an astronomical amount of money. And so in those states, it's almost malpractice to not recommend revocable trusts. Here in Tennessee, there are a couple situations where I recommend them to my clients. In those situations, I would always recommend them. Those include blended families where you have children or grandchildren from prior marriages. Joint trust between a husband and wife in that circumstance allows you to have a lot of good control over how that property is managed and how it passes at both parties' deaths. And when I have clients who own property in more than one state, I strongly encourage them to consider using a revocable trust, because then you're not only avoiding probate in Tennessee, but maybe you're avoiding probate in Florida or North Carolina or California. Revocable living trusts can be excellent if they are well prepared, if they're well funded. They can be faster to administer than a will, and they can just work as a fantastic will substitute. So these are the basic types. I'm sorry.
I was just going to chime in and say, when you said faster to administer, what type of time scale are we talking about between a will and a trust?
So it's very jurisdiction specific, but here in Tennessee, there is almost no circumstance in which a probate lasts less than 6 months. And we're more often looking at the year mark and a little past the year mark. And so it could be as long as a year plus before you're making distributions from a probate estate. Whereas a revocable trust, it passes, the property will pass according to its terms. So in our office, we use a drafting rule of thumb that we like to do a 90-day survivorship period. And so when things are running smoothly, our trustees could be in a position to make distributions within 90 days, and other offices or other sometimes clients will specifically want shorter periods of time, 60 days. I've seen 30 days, but it is a night and day difference in timing between probating the will versus administering the revocable living trust.
Yeah, I just think that's an important point. Because I've heard people who are resistant to getting a trust because they say, oh, well, I have to pay my attorney a little extra to create the trust. And you have to say, well, there's a lot of benefit, or there can be, depending on your individual situation, to getting the trust in place.
Absolutely.
And then I just want to bring up, we got a question and that Danielle answered already in the chat, but I don't think the Q&A box appears for the recorded video. So I just wanted to mention it out loud. On the healthcare power of attorney, you should get that in place even if you're married.
Absolutely.
I don't know if you want to, either of you or Danielle want to expand on that.
Well, my answer was, I tried to be quick. It's just, that's so that the doctors know what to do with you, basically. I mean, the doctors are held at a high standard. Their job is to try to save your life. And sometimes using means that you don't approve of, that you don't want. And unless you have a document in place and you've got family members maybe fighting about it, the Terry Schiavo case, and I think it was in Florida several years ago, was huge, where the parents and her husband were arguing about, whether or not she'd want to be kept alive. It was awful. I mean, it was horrible. So yeah, absolutely. Everybody wants a healthcare power of attorney. If you don't have one, if you're going in for surgery, you can drop a copy off with your doctor, take one with you to surgery. It's one of the few first things they're going to ask for if something happens to you. Is they're going to ask if there's a DNR in place, a do not resuscitate order, and if there's a healthcare power of attorney in place.
Absolutely. I couldn't have said it better myself. And the problem is you won't know if that problem is going to happen until it's too late. If you don't have that power of attorney in place going into it, it might work out or it might not. And I've absolutely gotten those calls where it's not worked out. And then we have to do another route that is more expensive and
the other point, having just been through this with some good friends recently, is that the decisions you make while you are healthy will have a better chance of getting executed while people are stressed and grieving and feel guilty about making these awful decisions on your behalf. It is so much easier to take that out of their hands and off their conscience by saying, if I'm at the point where they're going to have to keep me alive, I do not want that. Just saying that and putting it in writing, it just takes a whole lot of stress off of your family when they're faced with those decisions to make.
Yeah, great point.
So these are the kind of some of the basic building blocks of an estate plan. And I think if we're ready for the next slide to talk about probative versus non-probative assets. We've touched on this already. Some assets will go through the probate court at death and some don't. And so what is the probate administration? That is where you file the last will and testament with the probate court. The probate court issues letters to appoint an executor to administer the estate. And the executor then endeavors to wind up affairs and distribute. So what assets go through probate? Assets that are owned in your name alone, without a named beneficiary, without a right of survivorship. So think of a bank account that is in your name alone, or a certificate of deposit, or a piece of, in some instances, real property can be treated differently, but a piece of real property that doesn't have a joint owner with right of survivorship. any of these assets could become probate assets. And when you have a probate asset, then you're in a situation where there is a piece of property that you can't access without filing that will with the court. And you start that probate proceeding, that 6 month to a year proceeding. So what's on the other side of that coin? What are the non-probative assets? Well, these are assets that you might own them. They may be your assets during your lifetime, but there is something that will direct what happens to them at your death. And so be that a beneficiary designation, a joint owner with that survivorship right. So some classic examples of non-probate assets would be a life insurance policy with an individual designated beneficiary. That beneficiary receives that policy without going to probate. Retirement accounts with designated beneficiaries, brokerage accounts with designated beneficiaries. All of these things will be non-probate assets. And perhaps one of the most important would be assets that have been titled in a revocable living trust. So in a revocable living trust, the assets are non-probate assets, which is how that document, that instrument, helps you avoid that long probate process. So I've touched on these briefly, but for specific assets, you actually can control whether they're going to go through probate or not. And so we've talked about some of the legal side of things using a revocable living trust, but there are some financial considerations too that your financial advisor can help you with that'll help you avoid probate as well.
All right. David, do you still want me to talk or do you want to do it?
Well, I do want you to talk, but I do want to make this point about the living trust. We had a client who had an attorney draw up a living trust to do some of her mineral interest so she could give it to her kids while they were alive. Well, this was not waiting until she died, give it to them while she was alive. And so she did that, spent quite a bit of money having the attorney draw up a fairly elaborate living trust. And then she got her oil check. She had some oil interest and her kids didn't get their oil check. Why didn't they get their oil check? Because the attorney didn't move the mineral interest into the trust. This is a very common problem. And I think it's very important before, when you're creating the trust when you're alive, that be done. That's another benefit though of the revocable living trust. Sometimes when people die, they've got a bank account in this town and they've got a brokerage account at this firm and they've got something else somewhere else. They've got a piece of property in Florida. They're all held separately in separate places. And then in a death situation, your executor or your administrator has to gather all that up and get it moved into the estate or get it moved where it's going. The revocable living trust before death is a way to consolidate all those assets into one place where they make sense. It doesn't leave a burden on somebody to find them and gather them up. They're already in the trust. Other than that, Danielle, go ahead with these other points you wanted to make.
Okay. I want to start by saying as financial advisors, well, 3 of us at our firm are attorneys or used to practice law, and Emily's a CPA, and our whole job is to make things easier. That's our whole goal. And I constantly repeat the terms flexibility and liquidity. Like, we want you to be able to get to your assets and we want them to work as efficiently as possible. And one of the ways that we do that is Patrick just went over probative versus non-probative assets. We don't like probative assets. Our goal as your financial advisor is to get everything in your hands or your beneficiary's hands as quickly as possible. We don't want you to have to sit in the court system if that's not necessary. And sometimes you can't get everything. And I've got some good friends who did really, really well on their estate planning. They still had to go to probate for some things. And that's where a good attorney like Patrick comes into play. But our job is to try to get things lined up for you and for your loved ones before it becomes an issue. And so we already kind of mentioned some simple things like life insurance, retirement accounts. You want to make sure your beneficiaries are up to date. We simply don't have time to check your beneficiaries on an annual basis. If you get married or divorced or have a kid or stop speaking to someone or whatever, make sure that your beneficiaries say what you want them to say. I did randomly catch some years back, one of our divorce clients, like 5 years after the fact, her account was still going to her ex-husband. And I was like, I'm pretty sure this isn't what you meant. She was like, oh my gosh. So this is super, super important whenever you have any big changes. David just touched on retitling assets and accounts. Your Roth IRAs, life insurance, those automatically ask you for a beneficiary, but you can also add a beneficiary called a pay on death or a transfer on death when it comes to checking and savings accounts and brokerage accounts. We always push for that, especially if we have a single owner of a brokerage account. We want to make sure that that is available to whomever you want it to go to. Sometimes it's the person who's going to handle it for everybody else, just so they can pay things. Sometimes it's the beneficiary themselves. But if you're looking at having assets tied up for a year, we don't want you to go through that. So that's one of the easy ways to do it. Some of the discussion, or our title today was preparing for a loved one's death. And one of the things that comes up is having cash available. There will be expenses. And for some people, that's worse than others. So we do want to make sure that you have access to cash, so that while you're going through this awful time, you don't have to worry about it. Like, just create cash available for you in a place where you can get to it, where a beneficiary can get to it. And that's an important thing. And last but not least, whenever I do estate plans for people or talk to people about estate plans, outside of those 4 documents that Patrick went over, the other one for me is just a list. And that can be a paper list, a spreadsheet, a LastPass savings, all of your password accounts. Your stuff is all over the place, and that's just how it is. If you have a trouble remembering your passwords, imagine what it's going to be like for somebody when you're gone. So you want a list of assets, debts, account numbers, contact information for creditors, login information. You should keep that up, check it at least once a year. Again, we use LastPass because we have so many passwords. If something happens to me, Emily Augusto is my backup. My husband knows to reach out to her because she can get everything that ever exists for me that way. So it's one of those things that we recommend as well. And I think we're going to move on to tax planning. Does anybody have anything else there that I didn't cover on? Any questions on financials? Okay. Okay, so the big question that everybody always has is, how much is the government going to take from me? And again, our goal is efficiency. Some things are simple, believe it or not. If you have an estate worth less than $12 million, that's the amount right now. That can change on a year-to-year basis at this point. But right now, it's $12 million. If you pass away and your total assets minus debts does not exceed $12 million, there's no estate tax that your beneficiaries are going to be worrying about. So that's an easy one. But as far as what to do before you pass away, if some folks have all of their money tied up in one type of asset, real estate, IRAs, bank accounts, CDs, we see a lot of top heavy types of portfolios where your stuff is really concentrated in something. And that's another part of our job as financial advisors, to try to diversify that a little bit for a variety of reasons. But one of the things that you can do, so say you're one of the lucky people who has enough money, or you're getting close to death and you're not going to spend all that money and you want to start doing something with it, you can give gifts. The easiest gifts to give really are to pay someone's medical bills directly to their provider, or to pay tuition for school. Like, that comes right off the top. It's invisible on the gift giving scheme of things. The IRS doesn't even ask about it. It's a really easy way to give gifts and not have to document it anywhere or file a gift tax return. You can also give out $16,000 per year in cash to any one person. If you are a married couple, you can give $32,000 to one person and not have to file anything. So those are the easiest gifts to give. You can give more than that $16,000. You can give stock. I hear that a lot. Parents want to start giving their kids some stock. You can do that. You do have to file a gift tax return with the IRS. It doesn't mean you pay anything. The beneficiary who's receiving the gift does not pay anything. It's just an informational return to report in case you end up passing away with more than $12 million in an estate. So say you give away $100,000 in your lifetime, you pass away with a $13 million estate, they're going to knock $100,000 off the top, and you'll still be above that estate amount. But it's just, for most of us, it's an informational return that you need to file. IRAs versus Roth IRAs. I have talked about this until I am blue in the face. I'm going to be really short here, but you can listen to it on other of our webinars, blog posts on our website. We talk about this nonstop. IRAs are pre-tax savings accounts, which means you have not paid any tax on that money. Whenever you put that money in an IRA or your employer makes a match on your 401k, it's going to grow and grow and grow. And all of your earnings will then also be subject to taxation, which is why a distribution from an IRA is almost always 100% taxable at your normal income tax rate. That sounds well and good right now while you're not thinking about it. But when you are retired or someone passes away and you inherit a large IRA, it becomes a very big deal. And we'll go into that a little bit more later. Roth IRAs, we love. They are post-tax retirement accounts. You pay tax on the $5,000 or $6,000 or $7,000 that you put in the Roth IRA, but the earnings grow tax-free and you pay no tax on that money ever again. I used to have a CPA say, why would I recommend those? You have to pay taxes on them right now. It's just a very short-sighted way of looking at it. We recommend that you have both. Most people have both for a variety of reasons, partly because we never know year to year what Congress is going to do to our tax code. From year to year, we don't know what your life looks like. There are some people in a lower tax bracket where an IRA distribution really wouldn't matter that much. And for others, it would be a very big deal. So we like to have a variety, not only in assets, but also an account type, so that you have a lot of choice about where to pull money from in the event of an emergency, in the event of an inheritance. And we'll talk about that a little bit more later. But when you inherit an IRA from another person, all of that money is going to be taxable to you. And under the Secure Act, passed and effective on 1/1/20, I would say that 2020 was the year where all awful things happened. IRAs became taxable much faster. Anybody who inherits an IRA who is not a spouse, and I'm not going to go into the details, but if you inherit an IRA, you are not a spouse, you have to withdraw that IRA in full within 10 years. So if you inherit a $500,000 IRA, you're going to pay taxes on $500,000 plus earnings over the course of 10 years. It's a significant amount of money. It's going to evaporate very quickly, especially if you're paying state taxes as well, depending on where you live. And while we do want them in a portfolio for a variety of reasons, Roth IRAs are much more long-term, I guess, pleasant to have as far as tax consequences go. Required minimum distributions: if you are 72 or older, you are required to take money out of your IRA. Most folks fuss and complain and they want to wait as long as possible to take money out of their IRA. You can take money out of your IRA starting at 59.5. And believe it or not, there are times we recommend that you do that. And part of the reason for that is to spread out the taxation of that. Once you remove it from the IRA, the taxes stop. You can do whatever you want with that money. You can put it in your taxable account. You can put it in your Roth IRA. You have ways of making the taxes stop on those earnings. So this year was a big year when the market was down. We were going, hey, you want to do a Roth conversion? You want to take money out of your IRA while it's low, because you're going to pay less taxes and we can roll it over to somewhere else and do something else with it. So lastly, know how your assets are owned. A lot of people don't. I'll say it. Who's on the house? I think we're both on the house. Who's on the car? I don't know. Know how your assets are owned. That's incredibly important. Patrick mentioned joint tenancy with survivorship earlier. If you are a spouse, you probably have your husband and wife own a house jointly. Cars, a lot of times it's just one person on a car. You might have to go to probate over your car. I mean, it's like Patrick mentioned, the ADT account. These are things that are just really, really important. So when you're making that list of assets and debts, knowing how those assets are owned is incredibly important. I'm done.
Okay, and so now we're going to transition into after a loved one's death, and Patrick's going to fill us in on some of the legal process there.
Hi, absolutely. So here, after a loved one has passed away, the first item on this list is the death certificate. And I will tell my clients when they contact me that to let me know that someone's passed away, that a loved one's passed away, that there's very little that we can do until the death certificate is issued. And so typically you'll work with the funeral home. At least here in Tennessee, the funeral home will help facilitate the issuance of a death certificate. And ideally, those are available in a couple 1 to 2 weeks time. But that can change depending on the circumstances. If someone passes away Outside of a medical facility, for example, if there's some questions, if there needs to be an autopsy, I've seen death certificates delayed 30 days, 60 days. That can absolutely happen. But once you obtain that death certificate, that is going to be what you'll need to sit down with a probate lawyer in case you need to probate a will or to collect other types of assets. So if you have a will, do you have to file for probate? And the answer is a resounding no. Not every will needs to be filed with a probate court, at least here in Tennessee. Here, when I meet with clients, I tell them that we are only going to file for a probate if we need to. If you have those probate assets, those assets in your name with no designated beneficiary, or you have an asset that has not made it into a revocable living trust because, as David noted, how important it is to fund your revocable living trust with assets. Well, if something is left aside and doesn't make it in, then yes, if there's an asset that we can't reach, then we file the will with the probate court. We file petitions, the court appoints an executor, and then that starts a process. Here in Tennessee and in my jurisdiction, I think I've mentioned that probate is really no shorter than 6 months. And so what's that process look like? Well, there's the time it takes to get the death certificate, and then to meet with a probate lawyer, to prepare the paperwork, to file it. And then that paperwork could sit on a court clerk's desk for a week, 2 weeks, a month, 45 days sometimes, before it is actually even processed by the court. And before the court issues its letters to the executor that give them the authority to marshal those assets. So that is, of course, certainly an inefficient process. In different jurisdictions, it is better than others. I mean, there are some where probate is just an absolute nightmare. What other reasons might you probate in a state? Sometimes it's useful if there are Medicaid issues. Sometimes it's useful if there are a lot of debts in an estate. So there's some reasons why you might want to probate. This is a decision that can really only be made in conjunction with an attorney who's reviewed your situation and looked at your assets and looked at everything and worked with you to decide what to do. But for those non-probate assets, what do you need? Well, the death certificate generally. So if you have a life insurance policy that has a designated beneficiary or a retirement account with a designated beneficiary, you're typically only going to need to send that certified copy of the death certificate, perhaps along with some documentation that is company specific, so a life insurance claim form, or for a retirement account, perhaps you'll need to send in the paperwork to establish an inherited IRA to transfer it over. But those are done without the need for the probate court's involvement. So the letters testamentary that might be issued by the probate court, you would not need those for your non-probate assets. And the last on this list, your trust assets. Those assets are the ones that, again, as David had mentioned, that you've done the work, you and your attorney and your advisors have done the work to ensure that your revocable living trust is adequately funded, that the assets that need to be directed to it or retitled to it have been directed to it or retitled to it. And then how are those marshaled? Well, your trust will say what happens to them. So your trust will appoint a successor trustee who can step into your shoes and take care of that business for you. And your successor trustee doesn't have to file that trust with the court, and they don't have to account to any judge or court clerk or anything like that. What they do is they'll need to show the asset holder, perhaps a bank or a financial institution of some type, their authority under the trust document, perhaps a death certificate, and then they're able to administer that estate quickly. That's not sitting on someone's desk for 30, 60 days. That is available immediately, or as close to immediate as is possible under the circumstances, because again, we still have to wait for that death certificate usually. So your trust administration is going to, in almost every instance, be faster, and it's going to be less expensive for your loved ones and for the person that you've named in that document. Your fiduciary is what we would call them, who's going to execute your estate plan in your revocable trust. So that's just kind of a brief overview, and I'm not sure if there are any questions or not, because I'm not seeing them, but.
Oh yeah, no questions have come in, but I think, here's one from Emily. She's wondering how often you recommend updating your will.
That's a great question. So there's kind of a rule of thumb and then a caveat to that. So I tell my clients that every 5 years is a good amount of time to take stock of your will, to look at it, or your trust, if that's what you have in place, and look at the people named in your powers of attorney also. So really your full estate plan should be looked at least every 5 years. And so in my firm, we actually affirmatively follow up with our clients every 5 years because we want to remind them about it. So that's the rule of thumb, but there's the caveat is, and it's a little tongue in cheek, but if anything makes you cry because you're happy or sad, is probably also a good time to look at your planning. So your major life events, births of children or grandchildren, marriages, when people pass away, these are all times when you want to take a look at your planning and just make sure that everything is still consistent with your wishes.
Okay. I think that's great. And she also asked, where do you keep your pre-death docs, like your healthcare power of attorney? Do you file them somewhere? And then after that, she also asked if someone could speak to the probate process outside of Tennessee.
For document storage, I mean, as far as your powers of attorneys go, healthcare powers of attorney, I think Danielle had mentioned, you might want to have that on file with your doctor. You might want to have that on file with specialists that you see. When you go into the hospital for a procedure, bring a copy with you. So they've got that in your medical records. At least in Tennessee, healthcare powers of attorney, financial powers of attorney are about as good. An original is about as good as a copy. So you want to keep those relatively available to you. For things like your will or your trust, the originals of those documents can have some significance depending on the jurisdiction that you're in, and Tennessee is one of them. So for those, we encourage our clients to keep those in a lockbox, a fireproof box, a safe deposit box at a bank, provided that the people that you name in those documents know where to find them.
Mm-hmm. Yeah, that's true of Illinois as well, from my experience. They're very similar, except Illinois takes a whole lot longer to do anything than Illinois does.
Be careful if you have property in Florida, especially real estate, because you can have a non-probate situation in your home state. But if you've got a piece of real estate in Florida that you don't have in a trust, or you don't have, some way protected for probate,
Joint tenant, yeah.
They 75,000 and up, they require a full probate, not a simplified probate or a small state affidavit, a full probate process. It's fairly expensive there, and a lot of properties in Florida are worth more than $75,000. So that's one to watch out for sure, because a lot of people like to buy stuff down there.
That's a good point. All right, are we ready to move on to, once you get through the legal process or you have non-probative assets, that's kind of where we come in. Apparently it wasn't clear that you're breaking up the pieces of pie, that's our job when we were doing our practice yesterday. So I'm starting with that in case anybody else is wondering what's going on with my apple pie here. Patrick already kind of mentioned, if you are inheriting or you know someone who's inheriting retirement accounts, IRAs, 401ks, Roth IRAs, annuities, Those are all treated a little bit differently, but the ones that we deal with the most are inherited IRAs, inherited Roth IRAs. Accounts from the deceased have to go there first. Sometimes you have choices about what you do with it. You can distribute it. You can roll it into your own IRA or Roth IRA if you're the spouse. So there are steps involved, but once you have a death certificate and the beneficiaries are named, it's just a matter of paperwork and a little bit of patience and time to get that done. If you're transferring non-retirement assets such as bank accounts, brokerage accounts, that's what we deal with primarily. Those are, you just move them to your own. So if you have your own accounts, those assets will move over. We have something called step up in basis, and I'll go over that under tax here in a minute. And then what do you do with inherited accounts and assets? Well, you tax plan. That's what I tell people. So even early on, we said, even if you're not paying estate taxes, taxes are not just going to disappear. When you sell assets is when taxes become an issue. And so on the next slide, we're going to kind of touch on that a little bit. So again, I have people call all the time. Oh my gosh, I just inherited $10,000. What do I do? I'm like, nothing. Congratulations, you got a free $10,000. They're ecstatic. I hardly ever get to say that. It's a very good day when I get to give people that information. But if you inherit stock, or you inherit bonds, or you inherit an IRA or a Roth IRA, the answer gets a little more murky. Again, I mentioned earlier that if you inherit an IRA or you're planning to leave an IRA to other people, be aware that the taxation on those have amped up considerably as of 2 years ago. It used to be that you inherited an IRA from someone and you took out a little bit of money each year and you could let it sit there forever if you wanted. You could wait till your own retirement. If, say, you're only 30 and you inherit an account. It's not like that anymore. Now you have to take that money out. It's a very big deal. It's incredibly accelerated. It's very expensive. So those are it's something we really want people to plan around. Roth IRAs are different. If the deceased had that Roth IRA for at least 5 years, you get that money free and clear. You can take it out and spend it all if you want to. Not that we encourage you to do that. You do have to take a little bit of money out each year anyway, but you're free to do with it what you like, and it's sort of invisible on your tax return. I mentioned earlier a step-up in basis. If you inherit stock outside of a retirement account, so say somebody has a Robinhood account or a Schwab One account or a Fidelity taxable account, and they're leaving you Microsoft stock. Say it's your grandmother's Microsoft stock. She's had it for 30 years. It's, she paid like $10 for it. Now it's worth, I don't even know what Microsoft stock is worth today, but a lot more than $10. If grandma had sold that stock before she passed away, she'd be paying a considerable amount of realized gains on that stock. Say it's worth $100, subtract her $10, she'd be paying capital gains on $90 per share. When someone passes away and you inherit an asset, instead of the original tax basis of $10 that grandma paid for it, you get the value of the stock on the date of her death. So the $10 goes away, and now it's worth $100. So if you choose to turn around and sell it right away, you're not going to pay any taxes. Even if she only owned that stock for 3 years, you won't pay any taxes, and it's considered long-term. If you decide to hold on to it for 5 more years and it goes down, you can actually sell it at a loss. So that's how step up works. It was on the chopping block with Congress last year. I don't know what they're going to do with it. There's some discussion about how unfair it is and how much money they're leaving on the table by allowing these step ups. So we'll see what happens, but that's another reason why we recommend all the types of accounts, because we just don't know what Congress is going to do with the taxes. When will taxes be assessed? So if you take money out of the IRA, you're going to pay taxes on that as if you earned it. And if it's in an inherited IRA, it doesn't matter how old you are, you don't have to pay your 10% penalty. On your personal IRA, if you take money out before the age of 59.5, you have to pay a 10% penalty plus taxes at your regular earnings rate. When it's inherited, the 10% goes away, and you can take out a little bit at a time and not worry about it, but you still have to pay taxes on it. So say you're in the 22% bracket and you take out $10,000, you're going to pay $2,200 in taxes on that $10,000. So be aware that if you need to net $10,000, then you need to withhold an extra, $2,400 roughly, and you're still going to pay taxes on that. So all the money that you take out of an IRA, even the amount that goes to taxes, gets taxed. So it makes IRAs go down in value pretty quickly when you put the taxes back on the shelf and how much that's going to apply to you. So what are your options? That's why we do planning. That's what all of us here do for a living. That's why we have jobs. This stuff is very complicated. Don't be shy about asking questions. Don't feel shy about asking them 3 or 4 times. This is not easy stuff. Our tax code is complicated. Our legal system is complicated, and it changes all the time. So not only that, your life changes all the time. What's happening to you and what's going on changes regularly. And that's what we do for a living is try to mitigate the misery as much as we can by planning ahead before something happens. I think on our next slide, we're just talking about.
I want to add something on the financial planning part, Danielle, because people are often, first of all, they're often surprised. They don't necessarily know what they're going to inherit. Sometimes their parents or other people that have money saved up, they don't tell their kids what they have. And so there's a question of surprise. There's a question of it's all new to them. And more importantly, the person that inherits the money will probably have very different objectives than the person who owned it in retirement. The person in retirement may have wanted a lot of cash flow from, for living expenses. The person that inherits it may want to save it for a longer term purpose. So there's a change of purpose almost immediately. And step up in basis, it gives you an opportunity to make changes in it more readily than in normal situations if it's in a taxable account. So those are important. Sometimes if there is an estate or if there are claims in a probate, it's also important to preserve that capital. Sometimes you inherit things that are kind of risky. And if you're an administrator or an executor and you're responsible for paying claims, but in the meantime, the money that you had to pay the claims went down in value because the stock market went down, you can have liability issues that start to come into play on that. Plus, it's just not being a good fiduciary if you don't preserve capital when somebody else has a claim on the money.
Good point.
I would just add one thing is that I spoke with a client who went through this past year and asked her if she had any thoughts on what the process was like. And she said the key thing for her was having the relationship in place with her financial advisor and having someone she could trust, because she wasn't really functioning. She was grieving and saying, you can help me, tell me what to do. I don't know how to do this. Because when you're grieving, you're not in a position where you can figure this stuff out. You can't think it through. You're not going to be thinking straight. So, if you're in this situation, this is really the time to reach out to a professional, get that financial or professional help, because you can make really big mistakes with big tax consequences, financial consequences, all types of things. So we're here to help, I guess, is what I'm saying at the end.
I can't believe it, but it's 5 till our time is up, 4 till.
No, so I'll go
what
ahead
other questions? What other questions do people
please go
have
ahead and put
while
in
you're
questions.
doing this? Yeah, go ahead.
I'll launch the poll
Okay.
for a little bit. Can everybody see it?
Oh, it won't let me vote.
I wanted to vote, but I couldn't vote.
I think
Yeah, I wanted to vote as well.
I can demote you to a participant, and maybe then.
Okay, it's all right. I know what mine is. I can throw
Okay.
mine out there.
Okay.
If anybody has questions and they just want to talk, I think Amanda can let you talk if that's easier than dealing with Q&A. Just raise your hand and let us know if you want to talk a little bit.
Yeah, I can do that. So, I think we've got another vote in. So I'm going to go ahead and end the poll and share the results. We had 5 votes. Can you guys all see it on your screen?
Mm-hmm.
Yes.
So we have 1 person who has done a formal estate plan. So 20%.
Congratulations.
But I need to update it. Yes.
Yeah, it's I can't stress how important it is. I think 3 times in the past year, I've had to like scramble to get somebody some very simple documents because somebody was literally dying and had nothing in place. And that is not fun. It's not fun for anybody. So please do this when you're well. That's what I say it all the time. Please plan when you're well.
We do that as well. I've had trips to people's homes who have
Hospitals. I had to do it in a hospital once. It's awful.
Yes.
Yeah.
And
I
we
do-
also know it's worse when someone dies suddenly and they don't.
Right. Then you don't even have time
to
to fix
deal with all
it.
these things without a plan.
Yeah,
That can cause all sorts of-
I can't stress enough the impact of grief and shock. When somebody gets a diagnosis, it's not the time to make these decisions. So please do this stuff sooner. I'm in the last category. I feel like I'm ready. I'm good. Not that I want anything to happen to me anytime soon, but I feel like we'll be okay. Nobody has any questions? I mean, there's a lot of material. I know we did a good job, but there's got to be other questions.
I think, just the important thing is it's one thing to know it, it's another thing to do it.
Mhm.
It's easy to put it off. So if you need an attorney, if you're not in Tennessee, if you're in Tennessee, Patrick's a great attorney. If you're not in Tennessee, I'm in New York. I can recommend people in New York. Danielle and David know a lot of attorneys in Illinois. If you need a referral to an attorney to get your legal documents in place. I think pretty sure you guys know people in Missouri and other, people.
Yeah, I don't know anyone in Missouri. I always say if I don't know anyone and we can't find anybody who knows anyone, just contact your local county bar association. They'll be able to tell you who practices in that area, in your area, and you can interview a couple people and see what makes sense. But it doesn't have to be a very painful process. Like I said, it's far less painful when you're well than when you're not.
The other
And
thing.
for a lot of jobs too, it's a benefit. It can be in your benefit package to get an estate plan.
Yeah, sometimes they'll have that.
Lawyer.
Go ahead,
So if
David.
you have a job like that, look in your
Mhm.
benefits package.
If you're outside of Tennessee or New York or Illinois, another resource, if you're trying to find good trust and estate counsel, would be the ACTEC directory. And so that's ACTEC. It's the American College of Trust and Estate Counsel, it's a great directory when we need to partner with a firm in, Washington State, where we may have absolutely no connection. That's our firm's go-to.
B asked the
Question on the Q&A there, guys.
Pardon?
There's a good question on the Q&A.
Yeah, I was just about to say that B asked the good question. Are canned online wills worth doing versus going to an estate planner? What do you say, Patrick?
Well, so not only does my practice involve estate planning, so preparing wills, and administration, so administering them, I also do trust and estate litigation. And homemade wills can be, and canned wills can be rife for litigation, because there are questions that need to be asked when we're developing an estate plan, that those forms and those documents, I don't care how good they might be, quote unquote good, are going to miss. And generally that ends up either costing more money in the long run, or you end up with a result that you wouldn't have wanted. So we deal with these on at least a bi-monthly basis. I would say some case comes before me that involves a homemade or a canned will. And when it works, but when it doesn't, it's not pretty.
I had to look at a canned will for somebody in Tennessee once, which, like I said, I was like, why? Like, it's so easy in Tennessee, especially. And I think people think that if they have this idea that their estate is simple, and if it's simple, then they don't need to pay for anything. And I was like, well, you just made it more complicated by having a bad document. But this particular document, they're like, well, you look at it and let us know what it needs. I'm like, okay. So I looked at it, and it didn't even have a place for 2 witnesses to sign, which is like, you have to have 2 witnesses in like most states. And in addition to that, we say have those witnesses' signatures notarized so that those poor people don't get hauled into court to confirm that they are who they said they were. And, people don't understand what that means. And we didn't go over it before. I know Patrick kind of said earlier about intestate statutes and how only 1/3 might go to the spouse. There is this huge misconception that it's like, if you think it like, well, I want everything to go to my kids. Well, you can't just think it like that. Just because you think that's what makes sense. That's, first of all, what makes sense to you does not make sense to everyone. And secondly, the law doesn't necessarily make sense. So, have it done right the first time. And not that I want to throw any, lawyers under the bus, but if somebody, heaven forbid, does make a significant error in your estate plan, you have recourse. If you pull something offline, there's no recourse. It's on you to make sure that that document reads the way it's supposed to read.
Absolutely. Every year we pay our malpractice premiums here at the firm. And so, if we mess up on something, it's on us. There is, the homemade wills there. Yeah, there's no one for that liability to fall back on.
Anything else? Thanks for being here for everybody. And again, this is one of our lower attended ones. I know everybody hates this topic, but we just keep making people listen to us anyway.
I think even if we help one person take the step in the right direction to get their estate plan done, then, did something.
Yeah, we didn't touch on this in here, and I'm going to touch on it really fast because I know there's at least one person who was on here who it applies to. We're a lot of small business owners in the world, and good B, Karen should watch. So I have a lot of folks who open up an LLC, or they have a C Corp and they have shares in something, and they have done zero estate planning for that business. That's a really big deal. And I love small business. Obviously, we're small business owners too. It's really important that you plan for what happens to that business when you pass away. I had a client recently, it's a tax client, say, well, I made the father of my children a partner in my business so that the kids would get my shares if anything happened to me. And I was like, what? That's not how it works. There's no actual partnership agreement. It's not mentioned anywhere in their estate planning. So that's another important thing that needs to be addressed if you have a small business.
Yeah, that's
All right. Well, we'll stop. 4:35. I'm so proud of us. You know where to find us if you need us. Thanks, Emily.
Thanks, Emily.
This
Thanks,
will be
everyone.
Amanda and Emily do some magic and make this video available on our website at some point. So you can share it with other people. You can reach out and ask them for, you're welcome. Thanks, Gail. You can share this with whoever you like. It'll just be a link on our website.
Okay, thanks, everyone. Have a nice day.
Thanks. Bye. Thanks, Patrick.
Thanks, Patrick.
Thank you for inviting me.